I want to welcome everybody to another Resident and Family Support Council meeting. These meetings we hold on the second and the fourth Tuesday of every month at 3 o'clock. And as I always say at the beginning of these meetings, same link that brought you to this meeting is the same link that you can use for every single one of these meetings. So keep that link handy. And join us for all of our meetings, because with these meetings are really great. I know I personally get a lot out of them from the conversation that can happen. I learn a lot, and I hope that everybody here also is learning a lot through this process. Having conversations that are important like this are, really meaningful for everybody. So thank you for attending. I really appreciate it. Today, we're actually going to be continuing our conversation from our last meeting, which we were talking about residents' rights. And we weren't just talking about residents' rights on the surface. We were talking about residents' rights pretty deeply and what it really means to have these rights. So what I'm going to go ahead and do is I'm going to start sharing my screen. And I'm just going to bring us through a couple of reminders here as we're starting off about the rights and what we're talking about. So let's hold on. Hopefully things will start to show on the screen. I want to encourage everybody through the course of this conversation to share how you've been able to express these rights. If you're somebody who who lives in long-term care, or somebody who loves somebody in long-term care, how you've been able to express things, or any challenges that you might have, or any questions in regard to any of these rights as we're continuing this conversation today. So we really want to make sure that we're going through these deeply so that everybody can truly understand them. So again, just to remind everybody about that mission of what our Ombudsman program is really all about. This program is sponsored by the Ombudsman program, and the Illinois Pioneer Coalition provides their Zoom account to let us be able to do this via Zoom, because we do not have a Zoom account through the state office at the Ombudsman program. So we want to say thank you also to the Illinois Pioneer Coalition for allowing us to use their site. So the mission of the Ombudsman program is really to protect and improve quality of care and life of residents through individual and systemic advocacy. And that individual advocacy, looking at what the people need, want, deserve, and then systemic, looking at some processes, looking at how things are done within the content of a long-term care community, and seeing if there's opportunities for changing there to make sure that people's rights are really being asserted and people are being listened to. So ultimately, the goal of the Long-Term Care Ombudsman program is to ensure that residents' rights are being upheld. And just as a reminder, residents' rights is nothing that's just, a piece of paper, just written on a piece of paper. They actually were established through the Older Americans Act in 1965. And to make sure that people that lived in long-term care communities that were receiving Medicare and Medicaid funding were having the quality of life that they deserved through getting those rights listened to. And it was in 1987 that there was more regulations, more meat and guts behind what all of this meant. And so regulations came into existence that really did promote that high quality of life for long-term care facilities to be held to. And then in 2016, there were some revisions to those regulations that they were actually passed in 2016, and they took a couple of years for some of them to play out. And they actually again helped to reinforce that long-term care communities are really there to honor people and their rights. And so there are also various Illinois regulations that also do support to enhance all of these rights. So that just brings us to this place of, remember, just because you or your loved one moves into a long-term care community, you still have all the same rights as anybody who lives anywhere in our country. You do not give up any rights when you move into a long-term care community. As a matter of fact, we actually have a saying in the Ombudsman program, you even gain some rights, because we very clearly define within the content of the rights that to make sure that these get adhered to. And so some of the things that we've already talked about during our last meeting, we talked about being informed of your rights and exercising those rights, making sure that people were comfortable and confident in being able to do that. We talked about being treated with dignity and respect and people making their own decisions and what that looked like, being free from chemical and physical restraints, being able to refuse treatment if you want to refuse treatment, being able to participate in your care and your treatment, looking like at your care plan meetings, you should be able to be a part of that, having access to your medical records and privacy. And this is where we left it off at the last meeting. Before we move on any further, I'm curious if anybody has any questions about any of those, any insights they want to share on any of those, or any comments that you want to share on any of these rights that we've already semi-reviewed, but that we talked about a little bit more extensively last time. Does anybody have any comments that they'd like to make regarding these? Okay. So with that, I'm going to go ahead and I'm going to move to the next right. And this is talking about discharge or transfer. So residents have the right to not be discharged or transferred except for certain reasons, and to appeal the decision and have a safe and orderly discharge transfer if the resident leaves the facility. So it's very clearly defined within the content of the regulations that people can only be discharged, and I don't have them in front of me, and then I always forget whenever we're doing these, but it shouldn't be that complicated, so let's see if I can do it. People, if you don't pay, you do have the right to be discharged from the facility or transferred from the facility. Care isn't free, so if you're not paying your bill, that is a reason to be discharged. You could be discharged because your care needs are exceeding the care needs of what that long-term care community can provide for you. Now that can be a reason that facilities will use sometimes, but it's really important to know that if your care needs haven't changed from when you came in to now, that is not a reason for discharge. If you don't have any advanced care needs, that it will not be a reason for discharge. But if you have care needs, let's say that you have trach care that needs to happen and the facility does not offer tracheotomy care, then you could be discharged from that facility because they do not have the nursing care nor the certifications to be able to go ahead and be able to provide that care for you. So that's what that can look like. You also could be discharged because you or other residents are at threat due to some behavioral issues that might be going on. So either there's threatening behavior coming from the resident themselves that's threatening others, or there could be that you personally are at threat due to something that's going on in the building that you don't feel comfortable, and so you could be discharged for that. You could also be discharged for, okay, I've got two more that I need to go. If the building closes, so if the building no longer is operating, hence you could be discharged for that. And Jessica, you might have to help me on this one. What am I missing?
Okay, I got to go through them. So non-payment,
okay,
did you catch non-payment? Facilities closing, danger to self or others. Your health is improved. Was that the one you're missing?
I said health declines. So is that, would that?
So if your health improves and you no longer need the care, so like if you get, that would be.
That's the one I missed.
Yep.
There we go. Thank you, teamwork. And so that can be another reason. If your care is getting better, your health is getting better, you no longer have a need for, if you're in, for example, if you're in a skilled nursing home, you no longer have that need, so you could be discharged for that. And this can feel very, very, when you're living in a long-term care community, you may have lived there for several years, and all of a sudden you get this discharged notice. I want you to know that you need to be getting a discharge notice. Is there a question? I noticed somebody turned their camera on, and sometimes that can mean that there's a question. If you have a question, please don't hesitate to put your camera on, raise your hand, or if you have a question about this topic. This discharge, you have to be issued a 30-day notice. So it has to be given to you and your representative in writing. So that's an important piece to know. People just can't say you need to leave and you need to leave tomorrow or next week. You have 30 days. You need to be informed for 30 days that this that they would like for you to leave or to be transferred or discharged. I see that there's a question by Sharon. Sharon, did you want to unmute?
Yeah, I'm just, I'm curious because I've had a couple of situations through our office that a person's condition hadn't changed, but they were not, they basically still couldn't walk or anything like that. And the nursing center was basically pressuring the spouse to sign the discharge paper, and like would basically try to find her away from her kids, and really bullied her into doing it, and she ended up signing the discharge paper. So I'm wondering if that's just something they can ask, because the person's condition did not change even though they couldn't walk or take care of themselves. The other question would be is I had somebody that went into a hospice facility, and because they said, oh, well, she could live another month, and you know, and they were trying to get her to leave also. And by then I already knew to tell them not to sign it. But again, that, you know, how do you stop these people from pressuring the individuals? Because as we all know, that 100 days is, once that first 14 days, they only get so much. And then after the 100 days, they get nothing really. So everyone's trying to shove everybody out on those deadlines.
And this can be a very, very complicated answer. I noticed Jess put her camera on. Jess, did you want to address this question?
Yeah, I'd be happy to. Anytime somebody asks me questions, I usually have like 5 to 10 questions that come back.
Right.
We've laughing because she knows I do this all the time. But I do want to just jump on that last thing you mentioned about the 100 days of Medicare coverage, just to clarify. It's my experience that most people don't get 100 days of Medicare coverage. It's up to 100 days of Medicare coverage. So for those listening who may not be familiar, I just want to make sure we make that clarification, because you're absolutely right. It's up to 100 days of Medicare coverage. But unfortunately, for a variety of reasons, the health improves or they're not improving or something else happens. A lot of people don't get that full 100 days. As you were talking though, with your first question, the thing that came to mind for me was I'm curious if maybe it's a situation where it's what we call a distinct part facility. And in Illinois, nursing homes that take Medicare and Medicaid are allowed to designate which beds are Medicare beds, which beds are Medicaid beds, or which beds are Medicare and Medicaid beds. Okay.
It was one of those.
And so for those who aren't familiar with that, let's say there's 100 beds in a facility. They may have 90 of those beds Medicare and only 10 of them Medicare, Medicaid. So if you're in one of those, if those 10 Medicare beds are full and you run out of money, your Medicare ends and you can't afford to pay, the facility is allowed to discharge you. I know Lee and the other ombudsman tend to say, like you were saying, don't sign it. And the other thing is don't leave until you're forced to leave. So residents have a right to this discharge process that Lee's talking about. So if someone is telling you, coercing, I mean, you can make a complaint to the Illinois Department of Public Health that they're not following residents' rights. The law is tricky, I guess. Tricky is probably a bad word to use, sorry. It's complicated around distinct part. I will say that. So if the facility's informed you when you came in that it's distinct part, there's different interpretations of the law related to whether or not they can tell you have to leave. But I always encourage people, if somebody says a resident needs to leave the facility, to say, are you going to issue the notice of involuntary discharge? Are you going to issue me the paperwork? And ask for the paperwork, because that paperwork lays out and gives you the ability to appeal. Like the appeal form will be in that paperwork they give you. So
okay.
I think your advice with that, we don't go to hospice facilities, but your advice there, to not sign something or I think that's great advice.
Yeah, the poor
but also
family.
to not
Don't
leave,
sign anything.
Right? Don't leave until
yeah,
a judge has ruled that you have to leave, unless you have another place where you want to go.
Right. And she ended up passing 2 weeks later, but still, I just, I was, by then I had already knew part of the system, and that's why I told them not to sign anything and not to take her out. Like they can't kick her out. So,
Yeah.
so good. I appreciate that. I did not realize there were different issues with the
Yeah,
bed.
and that distinct part is, it's unfortunate, really. Not every state allows for it, I don't think, but in Illinois, it is part of our system.
Yeah, in the
And
first case, it was a person that was going on Medicaid. So that makes sense. Okay, thank you very much.
so there's a couple of things I think that's important for everybody to hear, and what Jessica just shared with us is really that 100 days. Many times people they go in thinking they're going to get their 100 days of Medicare services. That typically doesn't happen. I've had friends say to me, oh, we could breathe a sigh of relief. Mom now has 100 days in the nursing home, so we could figure out what the next thing's going to be. And I'm like, no, it's up to. And that up to is one of the most important things. So that's important for people to understand that. The other thing is, I think that don't sign anything. And that's a really important message. The other message, don't leave. That's an important message. You have the right to appeal that decision and contact your ombudsman. Your ombudsman gets these notices of discharge, and your ombudsman can help you. They deal with this a lot. They can help you. They can point you in the right directions if you need to go, if you're going to be appealing it, what can happen, what that will look like. They can help relieve some of that anxiety because they can help paint a picture for you. So I want to encourage you, use those resources. We have done some of these resident and family support councils on discharges. I would encourage you to take a look on our YouTube page if you're going through something like this. It's well worth it to take a look at those. I also think we probably should do another topic around this in the near future. So we'll be looking at that as well, and what discharge planning should really look like, because the long-term care communities really are tasked with doing long-term with discharge planning. If they know you're going to be discharged, it can't just be, here's your papers, leave. There should have been some planning happening along with this, so that you had a good, healthy discharge as well. So I think that might be another topic that we should be addressing in the future. Anybody have any other comments about that? This is a scary thing. Go ahead.
Yeah, I've heard from Stephen. Yeah. Today's story from Stephen is that he got bit by something, and his face is all swollen up, and so I'm trying to get him to go to convenient care, and he's reluctant right now. He said, well, I'll see if it gets worse, I'll go. But
oh geez. Well, thank you for keeping an eye on that for us. Stephen, you need to take care of yourself. That's not good. We want to make sure that you're okay, Stephen. So okay, so another one of the rights that we should talk about is that residents have the right to communicate freely with persons of your choice and receive visitors. During the pandemic, this was one that actually had some revisions to it. Obviously, visitation was all over the board. There was a lot of scary things happening for people, but know that there's no reason left here anymore where we are right now at this day and age where you cannot be able to receive visitors. So if anybody's trying to limit your visitation with anybody, you have that right to be able to visit anybody. Even if you've got your power of attorney, let's say it's your daughter and your son is just your son, but they're not getting along right now. And so your daughter being the power of attorney says, I don't want my brother to come and visit you, so I'm not going to allow him. That is not, if you want to see your son, you get to see your son. The power of attorney doesn't determine that. You get to determine that. That's an important thing. We hear that fairly frequently. Somebody have a comment about that? Hey.
Yeah, Lee, I just had one comment, is that's one of the things that our group had looked at and did bring down to Springfield that was passed, is that if we ever have another lockdown where the facility says absolutely no visitors, doors are locked and that's it, they can no longer do that. They need to let you in as the ombudsman, and they also need to have their advocate / family member come in. Obviously, they're not going to allow 19 people in through the door for one person, but you can
Mhm.
have your advocate plus the ombudsman come in. That was
And
just passed, I think, last year.
Yes, and Sue, I'm glad you brought that up because there was a partner bill similar to that. It was called the Compassionate Caregivers, and everybody gets to designate 2 people as compassionate caregivers out, can never be locked out. So that's something that's important for people to know, is that
Absolutely.
everybody gets that opportunity to do this. And so know that, fight for that. If you're getting kickback on it, again, this is where you call that ombudsman who can help fight for that. Mary, I did
Absolutely.
see you had your hand raised. Did you have a comment that you wanted to make, Mary? Or did you?
Actually, you guys just covered it. Thank you for doing it ahead of me.
Great. Great minds think alike, right, Mary? Great minds.
There you go.
Lee, could you
I
mute
am.
Georgiana?
Yeah,
Okay,
there we go.
thanks.
The other is the confidentiality of records. So your records are confidential. Those are your records. And you have the right to only share those with people that you want to share those with. Those are yours and yours alone. So with that also being said, there is the right, I think, did we have that up above? Or it might be another. Oh, you have access to your own medical records, which we talked about last time. So those are your medical records. We really want to make sure that you understand that. So if a facility says to you, you can't have those are ours, please make sure they're fully aware. Those are not theirs. Those are about you. Those are your records, and you have right to have the access to all of your records at any time that you want to have access to your records. If you wanted a copy of your records, they may provide you with a charge. They actually can give a charge for those, up to the going cost, basically, of what it costs to copy, or for paper. So that a charge can be provided if you wanted a copy of those. But just to look at them, you should be able to look at them at any time that you want. Mary, did you have a question or a comment you would like to make?
Sorry, having trouble getting it off mute. Yes, and just so people know, be aware that asking for it isn't always enough. It took me over 3 months to get my medical records, and I gave them in writing a note, handwritten note, and took a picture of it, so I had a copy of it, that said, I'm hereby requesting all of my medical records and any written notes by any member of staff or within the facility, or any of those coming in as contractors for the facility, about my care. And it took me closer to 4 months, but over 3 months to get that. And it was asking constantly for it. What I found out was the big thing they didn't want to give me, because that would have included my care plan. And they didn't give me my care plan. I had to go back and get that afterwards. But, and I'd never seen it. I mean, I'd never had a conversation about it. I didn't even know it existed for the first year I was there. So it's not easy as it should be. I mean, that should be a no-brainer. And my ombudsman actually ended up getting involved with it, and she was getting pushbacks. They said they'd given it to me. I'm like, no, they didn't. I'm not confused about this. So yeah, it was a nightmare. So just be aware, not easy.
But again, if they gave it to you, you can always get it again. They're your records. So, that's not a reason. And the thing is it can take a while, sometimes, to get that physical copy of it, but know that you should be. Access doesn't necessarily always mean a copy. You also could say, well, I'd like to take a look at it while you're making a decision here. Well, not while you're making a decision.
We had a place that I could see it.
Yes. And you should be able to see it. That should be part of what you should be able to do.
So the only way I could get it was getting a copy of it. And they then tried to charge me, get this, $50 for a copy of it, just as an aside. I mean, it was ridiculous. I'm like, paper doesn't cost you that much. Neither does it cost you a printer. I worked in IT. I know this. So yeah, it was.
And sometimes that feels like a reason for not being able to get a copy, because not everybody can afford that when you're only getting $30 a month.
Well, and
Um,
I didn't have a trust fund, so I didn't have any money,
yeah.
literally none. So,
That's where it can get hard. And so that's something that actually needs to be addressed through legislation. We have to take a better look at this. Ebony, did you have a question or comment?
Yeah, yeah. One way to get around paying for your actual records is to say, I have this USB drive. I need a copy of my records. Can you put it on this drive? That way you don't have to worry about paying for a copy of your actual record.
Great idea, Ebony. Great idea. Sometimes they might want to try to charge you for staff time that it takes to do something like that. So again, this is a great time to be able to talk to that ombudsman, help problem solve with them. The more we hear about people not being inhibited from being able to get a copy of their records due to the cost, gives us more power to be able to address this at a deeper level and see if something needs to happen around this. And we could, and there's groups like Sue, who's on here, who's part of a senior advocacy group. I know Mary, you guys are. This is wonderful because that's something that you guys could be starting to look at even and seeing if something needs to be done around that. Mary?
and actually I had done that with the USB drive, but the application that they put our records in has its own formatting. So it's not like a Word doc, not like a .doc or anything that is readily readable in just a regular computer. You have to have some sort of way to translate that application. So even that didn't work. At least that's what they told me. I don't know if that was true or not, but they said that I wouldn't be able to translate it. And I actually talked to the IT guy. There wasn't one on site in this facility, but they put me on the phone with a guy that was the IT guy because I've got an IT background. I was like, I don't get it. So that's what he said as well. So.
And I do know from working in multiple different systems myself, in my past roles, that there was always the ability to be able to put into a PDF form. Because they might have to run copies, it might have to go to a physician's office that doesn't have that technology that's compatible, or an EMT, something along those lines. So there usually is the ability to put something into a PDF form. But again, I don't know what that entire process for many programs looks like, and if that's a time-consuming thing to do, how easy it is to have that happen. I'm not clear on any of that. So. Yeah, but you know what? It doesn't hurt. None of these strategies, none of them hurt to try. Another issue is to be able to receive mail. That may seem like that is such a basic right. Everybody should be able to receive mail, right? But you need to be able to receive mail, and I believe it's within 48 hours of when that mail arrived. So do know that, because I do know that sometimes there are buildings that the mail might go to the activity department, the activity director's on vacation all week long, and you don't get your mail for another 2 weeks and until the activity director gets back. So that's something, to be persistent about if you feel that you're not getting the mail that you should be having. Mary? Did you have a comment?
And it's a federal offense for them to open your mail. It shouldn't be delivered to you having been opened. That is illegal. Federal offense. And it happens all the time.
And many times it's in the initial paperwork. There might be an agreement in there that you don't even realize that you're signing that says that they can open up mail that comes from the state, because it may be like if you're on Medicaid, so it might be some correspondence for that. So they sometimes might put that in there, but that also can open up the door for, if you do file a complaint, they can open that up as well. So be mindful, you don't have to sign that stuff. They can, if it is something, they could just bring it to you and you can open it up and then say, yes, this is about my funds, my funding situation here. Go ahead. I want a copy of it myself. You could take a copy of it as well. So Mary, that's a good point. It's your mail. It's not the building's mail. Be mindful about what you sign when you initially come into the long-term care facility, because you may have signed away the ability that they may, you may have it in writing that you have agreed that they could open up certain pieces of mail for you. So be mindful of that. So let's see. Another right, and it's not working. See. Okay, everybody should have know about services and financial charges. So you should be able to see your bill. You should be able to see how much those services are costing, and you should be able to see that and verify that you've received those services. So if you're, especially if you're a private pay resident and they're saying that you're receiving restorative care services, and those restorative care services you're having for 45 minutes a week, make sure that you're getting those restorative services for 45 minutes a week. So that's important to be able to take a look at that at your financial charges and the services that you're receiving. To be able to manage your own money and control your own finances. So you should be given, if the facility is holding your money, you should be given a statement on a monthly basis or anytime that you want to see your statement so that you can know where your funds are going. And this is your money, the money that was being paid out to you to be able to pay for your care many times. So you should be able to have control of that as well. Freedom from abuse, neglect, and exploitation. Again, that feels like that probably should be a no-brainer. Abuse could be mental, physical, sexual. And many times it might just be this abuse, which could look like this neglect, this lack of care. How timely are people being cared for? When are you getting bathed? When are you being showered? Are you getting those? If you're getting it as it's been care planned for you, if you want it more, you should be able to get it more, because that's what it is that you want. And that exploitation, not being taken advantage of in any manner. And this holds true from the family side, the representative side, and the facility side, and also peer-to-peer. That's particularly when you have that freedom to be able to live in an environment where someone else that might be a peer of yours living in the building does not abuse you either. So it feels like that would be a no-brainer, but it is something that really does need to be stated in the residents' rights. To be able to present grievances and receive prompt responses from facility or the program. Remain free from threats of punishment, retaliation, as a result of asserting their rights or filing grievances. We just did a couple of weeks ago a whole thing about retaliation and what that retaliation is real. I know Mary was one of the ones who joined us in this conversation and really helped talk about what this retaliation can really look like. Mary, do you have anything that you'd like to share with us in regards to this retaliation?
Yeah, and for those on the call that are in nursing homes, they'll recognize, I mean, the obvious retaliation is you report something and suddenly, people are, smacking you as you go by or yelling at you. I mean, it's very obvious. But there's also the little things that happen in a nursing home. Keep in mind that all of the residents' control of their life is really pretty much removed from them when they go in. I mean, it's just a fact of life. They decide when you eat, they decide when you shower, there are just so many things that just go out of your control. So because of that, it can be little things like, they don't respond to your call buttons for a very long time. I mean, I knew one person that was in a nursing home where she went an entire weekend and they never responded to her call button, and it was never turned off. They just never responded to it. It was still going on Monday morning when the first shift came in and they came in to talk to her. I mean, that's extreme, but it can be little things like taking a couple hours to respond to a call button. It can be saying kind of things that are just nasty. I mean, they're not out and out cruel, but they are just not appropriate for a conversation, and it's mean. I mean, it's just being mean, and it's hard to prove or put your arms around any of that, but you know it when it happens, and that's the hardest part of retaliation.
And I think, Mary, what you said is it's that feeling, when something's changed in a relationship with somebody, or when a relationship is not functional, that something is, it doesn't feel like it's coming from the caring place, it's coming from a different place. We're human beings and we do have this sixth sense about us. That retaliation also, I know someone shared on a retaliation, it could look like you ask for a glass of water, they bring it to you, but they put it across the room and you can't get out of bed on your own. So they brought you the water, but the water was put in a place that you could not easily access it.
Absolutely.
Or it could be getting the last tray during a meal. And you're always the last one served, so your food is always cold, or other people already have their trays and they're being served and fed and people are all eating and you still haven't gotten your tray. So it can look very subtle, but it can feel very personal.
Well, and it happens once, no big, but it's the point that's really big in what you said is it's happening regularly. Maybe not every meal, but more often than not. And it's those kind of things where, like you said, you just know it. I mean, someone may be just giving you the cold shoulder that you've always been able to talk to, hi, how you doing? Just really friendly with, but suddenly that member of staff seems to be giving you a cold shoulder, and so's the rest of the staff. So something happened with one, and it can permeate staff, especially groupings like nurses and housekeeping, whatever that grouping is. Suddenly you'll find everyone in that grouping is having problems. So yeah, I mean, it's things like that that are hard to prove. I mean, really hard to prove, but they're happening.
Yeah, right. So trust those gut feelings. And if you're feeling that this is happening, that actually is a violation. So that's a reportable. You could call IDPH, about the Illinois Department of Public Health. Also, you could speak to your ombudsman about it. So, and it's worth exploring if you're feeling this way. Ebony, did you want to say something? You're muted.
I'm sorry. Just to
That's
add
okay.
to what you and Mary both said, someone described it as, I can't describe what it is, but I know it when I see it. And also to put out there that that's actually what our House Bill 3716 is about, to help protect residents and for them to be able to be compensated for retaliation from a facility. I myself personally have had it to where they withheld my medication, and it was vital medication, a blood thinner that I have to take every day. And I went about almost 2 weeks with them saying, oh, it's coming, it's not here, it's not here. And the whole time when my regular nurse came back, the medication was in the refrigerator. So
yeah, right. Yeah. I did see a note in the chat as well that says, is there something that says about the restorative services are required at least 45 minutes a week? And when I talked about the financial charges and services, no, there isn't. It depends on what your payment, if you're in a restorative programming, what that may look like if you're Medicaid. And I can't speak to what those minutes are and the numbers of times. I haven't dealt with that in such a long time. But Nick, if you would like me to get more information on that in regards to what that looks like if you're receiving Medicaid and you're in a program for restorative care, I could get you that information. But there is nothing, restorative services may not be something that everybody gets anyway. Long-term care facilities are tasked with making sure that you don't have decline in your ADL services. Some of it is natural, occurred according to disease processes, but they have to do whatever they can to try to keep people functioning at the highest practicable level. So that's something that restorative services typically focus in around that, and it may not be that many minutes. So Nick, if you're interested in that, just let me know and I will go ahead and I will actually put my email address in here again. So you can email me, Nick. That way then I can send you links to any of the stuff that I further explore for that question. There we go. So I wanted to also address the beginning of this this dot point about that residents have the right to present grievances and received a prompt response from the facility or program. So I think that that's important. If you present a grievance, there should be a grievance policy that every home has, and that grievance policy, you can ask for a copy of that to make sure that they're adhering to that policy. Because when you have a grievance, they are required to give a response back to you about that grievance. It can't just be, well, thank you for that, we'll look into it. There needs to be a response provided to you about what that grievance is about. So that's an important thing for you to know. Mary?
And the policies are a whole other issue. We probably should talk about that at some point too. But
Yeah.
I had to find a facility that actually have written policies. And I actually had the VP of QA for the facility I was in tell me that we didn't need to have a written policy because it was all in her head and our administrator's head.
Oh,
Yeah.
well, that's not right. You do have to have a
Yeah.
grievance policy.
And I said, and what I said to her was, and that's great, except that your staff don't know those policies that way, because I've had different staff tell me a very different version of the same policy. It needs to be written. And she just disagreed with me and said, no, it doesn't. So
Well, that's
that was
actually
not easy either. It's a whole other subject, but yeah.
Yeah. There actually is a list of certain policies that facilities have to have, and I believe that's on the list. So that should be happening, because if there was a complaint filed against, that's one of the first things that Illinois Department of Public Health is going to ask is for a copy of their grievance policy. So, Ebony, did you have a question or comment?
I have a question. Is there a certain amount of time that they have to respond to your grievance?
I don't know if anybody else, any of the other ombudsmen on there know the answer to this question. I don't. I'm writing this down. Respond to grievances. I believe it's typically spelled out in what that policy is. Because I know one of the things that we will do as ombudsman is when we get a grievance and the resident says, I already told the facility about this and nobody ever got back to me. What's one of the things that we will do is ask for a copy of the grievance policy, and then we'll hold them to it. We're like, well, according to the resident, here's the copy, like Mary did, perfect. She wrote this, she took a picture of it, that you could even see the date on it when she took the picture, and she gave it to you. And it's been 2 weeks now, and she hasn't heard anything back from it. And according to your policies, it says you'll get back to them in 1 week. So she deserves her response now. So I typically see it in there, but I don't know if there's a regulatory guideline around it, but I can look into that, Ebony.
Yeah.
I can look into that.
Hi, my name is Crystal. I'm very new to the Ombudsman program here at DuPage, week 2. Having worked in skilled facilities for quite amount of time, there isn't there isn't anything written in stone, but as you said, is it Nancy? That typically, I think the rule of thumb in most facilities is 5 to 7 days. And so I, as a social worker in facilities at the time, it was just our duty to really apply pressure on the administrator to make sure that it's resolved. I would say just kind of hound the social services director, because typically we were kind of like the keeper of those grievances. So I would say typically between 5 to 7 days, and that's been across the board.
That's good to know. Thank you for that. Thank you. Crystal, right? Crystal, welcome, Crystal.
Thank you, Mary. Thank you.
Love having you as part of our program. So welcome aboard, and glad to see you're here. Mary, did you have a question or answer, response?
Yeah, just a heads up. I actually was resident council president when I was in a facility for a year, and every month at the resident council meeting, I took copious notes by grouping of whatever the facility divisions are, and I updated it regularly. When I got information back, I would go to the person who put it in. The facility never saw that person's name, but I would go to the person and say, here's what happened. I would talk about it in the next resident council meeting. But most of the things I collected that entire year, every month, didn't ever get responded to, and the state got a copy of it every single time they came in. And nothing was ever done about it. It made no difference at all that nothing was done. I told them I
Mm.
met with the activities director, I had met with the administrator, and nothing got resolved. I mean, that's not nothing, but I think it was 75 to 80% of them didn't get resolved, and was still not resolved when I left.
Yeah, and this is one of those things as we look at person-directed living more and valuing that input from the residents, because I mean, you guys live there, and as a long-term care community, we should be valuing what the people that live there say, because if they're happy, life will be good, complaints will go down. I will have a better survey as a facility. So we really try to encourage through person-directed living initiatives that residents get involved in the quality initiatives, their quality assurance programs, so that they can give that feedback so that you know where your problems lie, you know where your grievances lie, so you can address them before somebody from the state sees those grievances and brings them forward and make it a complaint, and then it becomes a penalty against you. Ebony, did you have a comment?
Oh, no, I had another question as far as
Okay.
the procedure in which a facility would process your grievance, because me personally, being in a nursing facility, and this is happening right now, let's say today I make a grievance, and the social worker will come and write out the grievance, and I'll ask for a copy of it, and they'll say, oh, we'll get you a copy after I give it to my boss and he signs it, or whatever the case. And when I try to express to them, no, I need a copy now, because that is my receipt that I made a complaint to you and that I filed a grievance with you. You know, that's my way of making assurances that this is what I said, and what I said was actually given to you. And they have a big problem with that. So is there any way that maybe policy can be made, or the ombudsman can
Well, I mean, right there, it says to be able to present these grievances. We can explore. I know Karen put a link in there. Karen, I don't know if you got to read that link much, which is a fact sheet about complaints. I don't know if you have anything to be able to share with that as well. Any other more regulatory guidelines around complaints. But I think what you're doing, I would just stay there until they gave you a copy of it. Just bring it down to the administrator's office, go to the copier and say, I'm staying here until I get a copy of it. I want to make sure. And even with a date stamp on it, if that's what you need to do, this is feeling like there's becoming a lack of trust, and you want to be able to say, I trust you, and I want you, we need to have this has to be a trust issue. So I want to make sure, I need to make sure here, and this is how I'm going to be able to trust you until you can prove to me that you're listening to what it is that I'm saying. Because this is my life. I live here. I live here every day. I lay my head on the pillow here, not you. And I think that's important. Nick also did make a suggestion, saying that many times you'll see it in the like the front hallway, that you might see complaints in like their policy about that stuff in the front hallway. I see that Karen did respond. She doesn't have a microphone. So, or Nick, I'm trying to get up to this. Okay, so we've got Karen gave the citation in the chat about grievances and what that looks like. For those of you who are on the phone, it says a resident shall be permitted to present grievances on behalf of him or herself or others to the administrator, the Long-Term Care Facility Advisory Board, the Residents Advisory Council, state government agencies or other persons of the resident's choice, free from restraint, interference, and coercion, or discrimination, and without threat of discharge or reprisal in any form or any manner whatsoever, Every facility licensed under this act shall have a written internal grievance procedure that at a minimum sets the process to be followed and specifies the time limits, including time limits for facility response, informs residents of the right to have the assistance of an advocate, provides for a timely response within 25 days by impartial and non-affiliated third party, including but not limited to the long-term care ombudsman if the grievance is not otherwise resolved by the facility, requires the facility to follow applicable state and federal requirements for responding to and reporting any grievance alleging potential abuse, neglect, misappropriation of resident property, or exploitation, and requires the facility to keep a copy of all grievances, response, and outcomes for 3 years and provide the information to the department. The department means the Department of Public Health, Illinois Department of Public Health, upon request. In accordance, the tag number for this one is 574 of the State Operations Manual for Long-Term Care Facilities. The administrator shall provide all residents or the representative upon admission and at request with the name, address, and telephone number of the appropriate state government office where complaint may be lodged in language the resident can understand, which must include notice of grievance procedure of the facility or program, and addresses the phone numbers for the Office of Healthcare Regulation and the Long-Term Care Ombudsman Program. So that pretty much says everything that it is, the questions that you all have been asking. She did put the link up above in the chat, and it is was done at 3:42 p.m. That's where she put the link for what I just read. So we learned from this is that within 25 days, they have to come back to you with a response, and that there also has to be a policy, that everyone must have a written policy about this, and that you have the right to have that policy upon request. So that we want to make sure that everybody can have that policy if you would like to have that policy. So there's a couple of really important things that were voiced in there. So that's really, really great. Ebony?
No, I'm sorry. I just had lowered my hand yet.
Oh, okay. Okay, great. Okay, good. This is really great conversation around this because this is important that we all truly understand what is the expectation, because sometimes what we hear isn't always what the law states. So that's why it's always great that I got these people back behind me working away. Karen, Stephen, these guys are great with putting the links in there all the time to be able to back up what we're saying with those regulations. So thank you for that. Residents have the right to participate in a resident council. And resident councils, we've talked about this at these meetings previously, what a resident council meeting really should look like. And we'll be talking about this. We're going to be addressing this again. October is Residents' Rights Month. So we're going to be talking about this again so we can really make sure that resident council meetings are happening the way they should be happening. And there's regulations all around this stuff as well. But everybody has that right to be able to participate in resident councils. To participate in social groups and activities, go outside and get fresh air. I recently have heard some people, we've gotten some complaints saying that I'm not allowed to go out on our front porch. I'm not allowed to go out in the backyard of the community. They're not allowing me to go out there. And I'm not clear on why that's happening. So it's important that you know that you have the right to be able to engage in life as you want to engage in life. And that includes going outside, that includes groups, that includes going to groups. And it also includes just doing what it is that you want to do and how you want to spend your day. And last but not least is people can purchase and install audio and or video devices with consent of his or her roommate and after notifying the facility. So you can have an audio and or video device in your room. We've talked about this a couple of times during these meetings. I believe there's 2 videos out there that we have on YouTube that really goes over really nicely. I think Lawrence Wagner, who's on our call, I believe today, he did those for us and really talked really nicely about what it is and what that can look like. So know that you can have a video camera in your room, and that can be used for a family member to be able to see you and be able to communicate nicely with you and feel safer that their loved one is in this long-term care community. Or it also could be for sometimes with people they have a lot of belongings and they're not in their room during the day. They may be going out through the course of the day and they want to make sure that nobody's going into their room and taking any of their things. So it can look like that as well. So it can be done for a variety of purposes. But know that that's something that Illinois has passed legislation on.
Does the
I'm gonna back that up again because I want to see if anybody had any other questions or comments.
does the facility have to be notified as well, or just your roommate?
No, the facility must be notified as well.
And
They
do
have
they
to
have
be, they
right
have to
to
be
do it?
a sign. A sign has to be hung up in the building saying that somebody's using electronic monitoring, and then outside the room, it also would be, a sign would be hung up there to be able to, for people to know that they're going to be on camera.
Okay.
And so just, kind of in conclusion, as we're approaching the end of this meeting, just to understand that difference between what Illinois Department of Public Health does, they're the regulators, and what the ombudsman do as the advocates. So the Illinois Department of Public Health, IDPH, really focuses on the regulatory side, assuring that the nursing home meets their standards that are set by law. And what we refer to those standards is we refer to them as minimum standards. So I want you to be aware of that. That's what they focus on, making sure that those minimum standards to the letter of the law are being held to. They enter the nursing homes annually for annual surveys. And then also when complaints are filed, they also go into survey then as well. And they base their citations based upon the minimum requirements that are set forth by the federal and state government. Now, the ombudsman, on the other hand, we're advocates. So we focus in on the advocacy piece for quality of care and quality of life for residents in nursing homes. We go into every building in Illinois. Every long-term care community is visited at least once every 3 months at a minimum. Every long-term care home in the state of Illinois is visited at least one time. But if there's more going on or more need to be able to go, or there's case follow-up, or somebody calls, we're in there much more regularly. So many times it's exceeded that once every 3 months. We base our casework based upon requests for assistance by on behalf of residents. So residents call us, families call us, local law enforcement calls us, paramedics will call us that are in a building and might see something systemically happening, physicians, staff, families, friends. We can get phone calls from anybody, but it's always important to know that the client is our resident. If you make the call as a family member, you're not the client. The resident is always the client, and we move at the guidance of what the resident wants, not what the family member wants or not what the complainant wants. We always move forward based upon what the resident wants for their life. And the most important piece is our casework is often geared towards surpassing the minimum standards. So while the regulations may say this, we also believe in best practices. And sometimes we may say, you may want to look at this and have putting more onto a building because it's where people live. So IDPH, while they would love to be able to say, hey, it should be this, they have to hold to the regulations and the guidelines consistently. And they have to do every building from the same lens. Whereas we would look at it based upon the people who live there, what they need, what they want, what they're asking for. If everybody in the building is asking for ice cream, as an ombudsman, we would be fighting for people to get, or majority of the residents, I should say, we would be really helping to foster that along so that they would get ice cream after every meal. Whereas if that was a complaint to Illinois Department of Public Health, there's not that regulatory standard as much to hold them to for that systemic thing to make that change happen. So just to understand where that looks different from the regulators to the advocates. I think that's kind of an important distinction for us all to be mindful of. Also, just as a reminder, because whenever we can, we don't mind shamelessly advertising about the Ombudsman program and where you can call us. The information is up on the screen. You can visit our website and it will take you to this map. And you can see on the map, you can click on the map and the map will take you to who you can call directly in your area that you can contact with right away to be able to contact the ombudsman in your local area. And as you can see, every single county, every single city, every single long-term care facility in Illinois is covered by an ombudsman. Nobody gets missed. So with that, I'm going to go ahead and I will stop my share and see if anybody has any other questions.
Have you
Okay.
guys thought about a way to, sorry, this is Mary. Have you guys thought about a way to have that number that you call to find out who your ombudsman is, to allow that to, because right now it goes to the regional ombudsman, which depending on what's going on, it may take them a couple of days to get back to you. It's just the nature of, that's not a bad thing. It's just, and actually it's exceptional they can do that even. I'm well aware of how busy they are. But is there any way to have it go to a list of your ombudsman? And I know there's enough turnover that gets a heavy thing to manage, but actually have the numbers of the actual ombudsman. And I know things change and per facility. And really what would be perfect is to be able to look up your facility and have it say who the ombudsman is and their number, because that's actually, I mean, I know it's a huge management issue, but I'm wondering if you could tie it to your internal systems that have the database of who has what facilities. And if you can pull it directly from there, so when you update it from your personnel things, it goes automatically to the website. Just a thought.
Yeah, it's a very interesting thought, Mary. Unfortunately, we don't have, not different regions do it different ways. Some do it on a case basis when cases come in, and some ombudsmen are assigned to specific buildings. Or different communities. It's done differently. Also, it can change because sometimes if there's casework a lot in one particular community and there's not in some others, they might be flipping amongst themselves so that they have the time to be able to dedicate it to the particular, buildings that they're working with. So it's fluid. That caseload, it's not like a specific caseload that's set in stone for many areas. Some regions do it more specific, set in stone, and some don't. We don't dictate that as a state. Every region has its own personality. So we want to foster that personality and make sure that they're doing what they feel is best for their particular region. Sometimes it's also geographic, as you see on that last slide. Some of the regions are very large geographically. So if a complaint came in and this wasn't necessarily the building that I was quote unquote assigned to, they may ask me to pop over there, or I may volunteer to go over there to see if it's something that needed further exploration or was it a quick fix, so that the person that was assigned, quote unquote, to that building didn't, have to make that 2-hour trip to come down there if it was something that could be resolved by a more localized person. So it's very, like I said, it's not a set in stone procedure. So the best way is to get a hold of that local regional ombudsman, and the regional ombudsman always know who's assigned to what buildings so that they can help that get out there as quick as possible. If you feel, we typically, when a complaint comes in, we have up to, I believe, somebody's going to have to correct me on this one because I haven't done a training in a while. I think it would be, we typically have a 21 days, I think it is, but we try not to operate by that. Again, based upon the triaging of what that looks like. We try to get out there. Some programs try to get out there again within 72, some do it within a week. And sometimes when people also don't realize, we get a phone call from a family member and the family member will lodge a complaint. We go automatically, they said, my father, John Doe, he lives in blah, blah, blah. And as the ombudsman, I will go out. I might not talk to the family member. I will go right out to talk to John Doe, my client who is a client, and say, I have received information that this potentially is an issue for you. Is it? And he may say it's not. And he may be like, I don't want you to do anything with it. And I really don't want you to call my daughter back. And because he's the client, we cannot go back and tell the daughter. So this is where we get that phone call at the state office saying, I filed a complaint 3 months ago and no one ever got back to me. And we look at the casework. Somebody did, but the husband, the son, the father, whoever did not want, as the client, did not want us to go back to the complainant to give them information. And we have to abide by that. So that's where it gets sticky. So I hope that makes sense. Did that make sense to you, Mary?
Yeah, that made sense. Thank you.
Okay. Anybody have any other questions?
Yes, Lee, this is Patricia Canesa, now living outside of Illinois, but always keeping Illinois in my heart. One of the things that I didn't see in your list is the fact that this facility needs to be making the best decision for medical care for any resident at the time of an emergency or an unexpected complication, which is very likely to happen. And I cannot take away from my mind all these issues of Legionnaires' disease that we had. And there are several subsequent cases in some facilities, and there was no response, immediate response. There was a long-term response. The long-term response did return the lives of the individuals that were already gone because the research and investigation was not already done. So how you respond to that?
You know what, I'm in the office today and it echoes a little bit in here, so I did not hear that question fully. I don't know if someone else heard that question fully and can respond.
Yes, the question is regarding the response, the responsibility of the nursing facility with unexpected medical conditions in which the best decision needs to be made on behalf of the patient. I believe that it's very easy to target complaints. Yes, when the person can have a very identifiable complaint, no food, no water, but usually the participant is not knowledgeable about the complications that she is suffering while they are in these facilities. How we can enforce high standards of medical care on these facilities?
Oh, Patricia, that is like the question, that's the $95 question, or whatever it's called. That is the biggest question ever. Holding people accountable can be very, very difficult because, as I showed on that slide, between what IDPH does and what we do, we are not regulatory. So all we can do is keep fighting and fighting and fighting for that advocacy side. IDPH is the only one who can go in and do the fining and do that holding them to the citations, and they can have that punitive piece with them. And unfortunately, they're not in the buildings like we are, like the ombudsman program is, because that's not their job. Their job is to do an annual inspection and to come in when there's a complaint. That's it. They don't do those frequent visits like we do it. That's not part of what they're supposed to be doing, and they don't have the manpower to do that. They have to be held in the regulatory lens. So because of that, there could be a complaint where people are not getting water. No one's getting water. No one's getting water. Well, the day they come in, everybody's got water. So all they can do is look to see what it is that's happening. And they can try to go back and try to catch people on surprise. But it seems like the second you walk in a door, all of a sudden people know that you're there. And so these little complaints that might happen that could have the greater effect wound up actually can get very difficult to get to cite. So it's very, very difficult, Patricia, very, very difficult. With that, I'm just going to go ahead and just stop the recording.
I believe that is a major gap that in some way we need to respond, and to look how that is going to be monitored, and we could have autopsy reports on these situations in which sometimes or the family is very concerned or the patient has suffered irreparable damage,
And what you're always empowered to do is to make those complaints to IDPH and to keep making those complaints until you get the resolution, and keep doing it. Just because you make it once, if it happens again, you make it again. If it came back unfounded from IDPH, make it again and look at the wording. How is it worded? Is this a resident's right? Say it was a violation of my mother's right because of this. And say explicitly, it was a violation of this right because this is what happened, and try to help put some of those pieces together so that sometimes it makes the picture a little bit clearer when they come in to do that complaint investigation. But just because you make a complaint and nothing comes back in your favor, don't stop. Don't think, well, forget it. Keep doing it, because I know buildings that people have been extremely persistent, and it finally does get to a place where it gets turned around. Those numbers of complaints when IDPH walks in does affect their standings with IDPH. I'm just going to go ahead. I see some hands. I'm going ahead just to stop the recording right now so we can be mindful of the time for the video recording. So I'm going to stop that, but we won't end the meeting.